It is probably the most critical thing that you have to do at this point prior to trial, is to ensure that you have not just disclosed, but potentially over-disclosed those opinions and what is required by the rule. Yeah, wiggle words are not going to save the lack of disclosure. I'll let the state know that right now. The fact that you say, well, he could talk about anything else, doesn't mean he's going to get to talk about anything else.
State's position, we've complied through our expert disclosures with Criminal Rule 16b-7, as well as your court's scheduling order. State understands the framework that you've outlined. We were under the same impression, and I don't think that there's anything else in dispute.
Yeah, so let me give you a word of caution. Sometimes there's dissonance between what an expert thinks that they're going to talk about and what the lawyer understands from that expert. And the lawyer submits these disclosures. And I think it's really important that you be on the same page if you don't have a specific written report from the expert about what it is they're going to talk about, and make sure that you have supplemented and that you have provided a listing of the opinions that are going to be provided and whatever else is required under the rule in terms of what that's based on. And I would encourage both sides to over-disclose those opinions in caution rather than under-disclose. Because two things. One, you may find yourself in a bad position if you're not allowed to go into an opinion you felt you were going to be allowed to go to because it's not disclosed. And two, I don't want to spend half our day at trial with me saying, where's that disclosed at? And then chasing the jury out while you dig through your thousands of pages trying to find where that is. And so the more exhaustive your disclosures, the less likely it is it's going to draw that objection, and the less time that we're going to waste at trial trying to find where you disclose that. And so I think sometimes, and I'm not saying you did that in this case, I think sometimes lawyers view this expert disclosure requirement as sort of tedious work that they need to get done in order to comply with the timeline, a requirement of the court, and then they sort of move on from it and forget about it. It's a dangerous tact to take. It is, for the case, one of the most important things that you can do is to understand what the person is going to testify to, and give a disclosure of what they're going to testify to, what those opinions are, and to be looking at that as you're thinking about their testimony, as you should be doing certainly now, even though it's months away from trial, on a continuing basis. So I would really stress the importance of that in a case, particularly of this import. And so don't feel like your job is done at this point, because I would suggest to you it's not. That you may consider needing to do some cleaning up and making sure things are more fulsome in the scope of those disclosures and what you're doing. The other thing, I think you tried to do to a degree is you thought, well, we think this is fact testimony, but, in an abundance of caution, we're going to put it in an expert disclosure. Well, if you're going to put it in an expert disclosure because in an abundance of caution it could be viewed that way, I suggest you treat it that way in terms of what you give. Okay. Thank you. And that goes to both sides. I haven't read your disclosures yet, so I don't know, where that stands, but certainly goes to both sides. And I know that also, the rules are different as to what the defense has to disclose necessarily and what the state does to some degree. And so I appreciate that.
Well, I think the court will anticipate that there's a rather large filing that contain a lot of actual reports. Your Honor, listening to the court's comments and understanding where we were a moment ago when we spoke, I feel like I must go through what their disclosures were because there are so many lists. My hope was that they would be limited because they didn't fulfill their disclosure requirement, and we did, and that put us at quite a disadvantage, not knowing what their experts would
Well,
say.
and if they supplement, you certainly can supplement based upon what they supplement. And I will permit that. And that's kind of the nature of the beast.
I do appreciate that. And should that become necessary, we'll definitely take you up on that, Your Honor. I want to make a record about some of their expert disclosures, though. All of the lab people, they have lab reports and notes. The Idaho State Police Forensics Lab, I better be really clear on that. Other than the wiggle room language, which would ask that they not be permitted to have any wiggle room language, the lab reports are fine, with the exception of one of the witnesses, Ms. Nowlin, that they've disclosed, and she's written no reports.
Is that the one they said is a rebuttal witness?
They said she might be a rebuttal witness, so I suppose now they know what our witness is going to say. I want to talk about the CAST report. The court's heard a lot about the CAST report. When I say CAST report, that's because that's what it's called. It's really a PowerPoint presentation. There's not any analysis in that. There's just, this will be my testimony. This is what it's going to be. Without much more, it's a picture, and it has some dots and some arrows. Your Honor, that needs to be cleaned up. We need to understand the analysis that went into coming up with those PowerPoint presentations. That's just not plain good enough. I would let the court know that the cell phone experts, there's wiggle language in both of those if the court hasn't seen that. Their disclosure number, that's Mr. Cox, that's a person that has not written a report at all. We have no idea, besides the state's disclosure, what that person's going to talk about. Agent Douglas that I talked about before, I don't think I need to make further record. There's a lot of documents, no analysis, no opinion stated. We put several of these in our pleadings, and so I won't go through all of them. I'm highlighting the ones that we're really concerned about. We have 3 that looked at digital data. The court should understand there's 60 some devices. There's digital data from third-party sources, and there are 3 people that are listed with just lists of things. It's Mowry, Tanzola, and Uric. They have lists of devices or social media accounts that they're going to talk about. That our expert told us would take 3 years to look at every bit of the data. So having no clue what's going to happen, I can envision exactly what the court's fear is when we get to jury trial, me wondering if this particular thing was ever disclosed. So I definitely needed to make a record of that. Further, with the lab personnel, there's a caveat that says they'll talk about other people's reports and other things that are outside of their report, in addition to some of the other wiggle language that I referred to. Your Honor, given that the state is now cautioned to think about those things and submit more, I feel like it's important for us to bring out that we have a right to confront the evidence that's brought against us. Bryan has constitutional rights, United States and state of Idaho constitutional rights for a fair trial and to confront evidence. The expert disclosures are designed to advise us of what the state is going to do. Their disclosures were insufficient. I appreciate what the court said, but exactly what the court's worried about will happen if we don't have better disclosures. The jury will be in and out while we make sure that we have a clean record. We appreciate what the court said today, and we'd ask the court to order the state to comply or for the court to exclude anything that hasn't been disclosed so far. That's it.
So I'm going to give both sides an example of what I expect, so that you understand. There's been talk in this case about DNA. If somebody's going to talk about DNA and your intent is they're going to let the jury understand what DNA is, and essentially going to do a mini course on DNA, I expect to see that in the expert disclosures. Not that they're going to do a mini course on the DNA. I expect to see the mini course in the disclosures, if that makes sense, in terms of what their opinions are, what their information is that they are conveying that is expert in nature. And so it really does behoove both sides to spend the time to do that. And that's the last I'll say about that. It is probably the most critical thing that you have to do at this point prior to trial, is to ensure that you have not just disclosed, but potentially over-disclosed those opinions and what is required by the rule. All right, is there anything else with respect to those?
Your Honor, is the court giving the state a new date to fix their disclosures?
I'm not giving either side a new date. You understand, I think, what I expect. So you can choose to try to supplement those. If they are simply expansions of what it is that they've disclosed that are just being more fulsome, I'm probably not going to have a problem with that, given where we're at in advance of trial. And then defense certainly can look at those and decide that they want to expand or change or whatever their opinions are based on that. If it's whole new stuff, then you're going to have to demonstrate to me, new opinions, new lines, or even new experts. You're going to have to demonstrate why you didn't get that in the timeline.
Thank you.
Okay, is there anything else that we need to take up today?
Nothing from the defense.
I don't know whether we're going to have a Frank's hearing or not. I need to go and do that. But if you don't mind emailing some dates that you have available in the next, say, 3 weeks to do that in the event that we need to do it, I would appreciate that. Okay? All right. Well, I appreciate everybody's work, not just for the hearings this week, but in this case in general. And I know how busy you all